Ms. Julones, this is opening for oral argument before the Supreme Court, which you all have accepted to do, is to go before, have oral argument before the Idaho Supreme Court. Well, here we are then, Ms. Julones. Did you not violate a federal law on this injured worker? Did you not violate the federal law 45 CFR Part 164 on the this injured worker? Did you send the injured worker a HIPAA authorization and direction for release of medical records before you sent for these records, Ms. Julones? Did you have a HIPAA sign release form so you can receive these records, Ms. Julones? No, you did not. So you committed fraud by federal law 45 CFR Part 164, Ms. Julones. I'm asking the Supreme Court to allow me to move forward to a federal court, or to move forward for prosecution. Ms. Julones. On August 11th, 2008, Ms. Julones, did you not violate a federal law 45 CFR Part 164 on August 11th of 2008? Ms. Julones, did you send the injured worker a HIPAA authorization and direction for release of medical records to sign prior to you receiving these records? No, you did not, Ms. Julones. You committed fraud on an injured worker. You violated. You got records that were protected by a federal law, 45 CFR Part 164, when you received these documents without my authorization. Ms. Julones, did you protect these records when you got these fraudulently before you sent it to other medical providers? Did you protect any names, addresses, numbers of anybody's other than my name that are in these records? Did you do any kind of safeguarding to protect any records that you received on August 1st, August 7th, or August 11th of 2008? Ms. Julones, on August 7th, 2008, when you received my records from Safe Corporation, did you send to the claimant prior a HIPAA complaint authorization, a HIPAA authorization and direction for release of medical records? Did you send me anything to sign so you can have these records in your possession on August 11th of 2008? No, you did not. Ms. Julones, you committed fraud against an injured worker. You violated and got private health records that's protected by a federal law. C 45 CFR Part 164. Ms. Julones, isn't it true that between August 15th, 2008, all the way through June 2009, well, that is my oral argument, you committed fraud? Clearly, in my opinion, you're still not entitled to those records because of what you had stated in your oath, in your deposition, how you had used those medical release forms. But then again, that's where this comes in, isn't it, Ms. Julones? Doesn't that show that you're lying in your deposition? Because if it was a fact that you had used them, used the proper medical release forms that were signed to get those records, then when I went in to clear my name, to clear that statement that was in the record. And then I just happened to ask them if I can review the letter that they had received from you all, from the state insurance fund, to receive my records. And they handed me this, and this is the only thing they had in their possession. Then obviously, Miss Jewel Owens, you lied in your deposition. Again, you see, that's why I did win, where Miss Jewel Owens was to testify in person when a hearing is set. But then again, that's how you all, without my knowledge, and Lynn Luker, you know, his corruptness, not doing his job like he should have. It's Jewel Owens. Oral argument before the Supreme Court. What records did Mr. Donahue use for his findings of facts and conclusions of law? Which I know that some of these statements from these records right here from this hospital was used at my hearing. But then I have like 4 or 5 different ways that the hearing has been set. So I really don't have a true copy of the original. So here, let me show you where this is all at, because you see, oral argument, Miss Jewel Owens, right here from the law firm of Anderson, Julian Hall. Affidavit of counsel, support a motion to compel. This was done September 2008. County Ada, Rachel M. O'Barr, being first duly sworn upon oath, disposed and says that the information contained herein is of your affidavit own personal knowledge. Okay. That your affidavit is an attorney of the firm that is counsel of record for defendants in the above entitled matter. 3. Claimant was injured in an industrial accident on or about April 17, 2008. Claimant was evaluated at St. Alfonso ER by orthopedic hand surgeon Dr. Dominic Gross, who continued to follow claimant's medical progress through May of 2008. That is a lie. Again, first impression readers. Through May of 2009, which is false because I stopped seeing him on the 2nd. Though I did go in on the 9th because I almost caught my house on fire. They told me, well, if Dr. Gross says that you can get it, that you need somebody to come in and cook for you a couple of days or whatever, then they'll consider it. So that's why I went on the 9th. So when you hear something about May 9th, when I went in based upon there because I also have a letter that I sent to him. Through May of 2008, which that's a lie. By correspondence dated June 5th, 2008, Dr. Gross notified the severity that claimant's care had been transferred to Dr. Robert D. Gross. But that is now I don't understand that one there because on June 5th, I was returned back to full-time, 10 hours a day, 4 to 5 days a week, based on a job site evaluation that he had supposedly signed off on that I found out over time. On June 5th. So I didn't even know that Dr. Gross had signed off on this job site evaluation yet. Dr. Gross notified Serenity that claimant's care had been transferred to Dr. Gross, but it wasn't on June 5th, trust me. Dr. Gross G. Hansen, a true and correct copy of Dr. Gross's June 5th, 2008 correspondence is attached here too as Exhibit A. I'm not sure what that June 5th thing is unless that's my letter. Claimant was first evaluated by Dr. Hansen on May 30th, 2008, which I had to fight because they weren't helping me with transportation, but they wanted me to travel 178-mile round trip to see a doctor when I was on all these medications. But anyway, in a July 7, 2008 response to an inquiry by the Severity, Dr. Hansen indicated that claimant was disabled due to his work-related injury and associated psychological issues from the date of accident through the date of the response. Now, in July, I filed a complaint on July 2nd. A response to an inquiry by the Severity. Dr. Hansen indicated that claimant was disabled due to his work-related injury and associated psychological issues from the date of the accident through the date of the response. A true and correct copy of Dr. Hansen's July 7, 2008 correspondence is attached to Exhibit 2, because in July 2nd, when I had filed my complaint against the Idaho State Insurance Fund, it was a complaint against the State Insurance Fund, not against my claim, is how were they able to get me back to work without seeing a doctor? And I wanted that $308 that they said that if Dr. Hansen releases me back off work, then they'll consider paying me that week I was off work. Well, he did release me back off work, and so I had to fight for it. Even though they didn't pay it to me until August 22nd of 2008. I didn't receive it until August 22nd in the mail. On July 7th, okay, this claim is accepted and medical benefits are paid as they are received in accordance with Idaho law. Furthermore, claimant continues to receive TD benefits during his recovery. A summary of benefits paid through September 18, 2008 is attached to here to Exhibit 2. But they're saying that I quit my job throughout all this other stuff. Now, how can that be? In their filings too, that when they forced me to go back to work when they tried to, and I said blah 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 blah. Well, they said that I quit my job and walked off. So blah blah blah. The Industrial Commission served a copy of claimant's workers' compensation complaint upon Crybaby Food LLC and the Idaho State Insurance Fund, which is who it was to, not the state, not the worker, not my job, but the state fund, because I wanted the money. Therein, claimant alleged he was entitled to time loss benefits for the time period of June 5th, 2008 through June 12th of 2008. Defendants filed an answer to complaint on July 25th of 2008. Thereafter, defendants paid the disputed time loss benefits in the amount of $317.83. Yeah, but you see, they're stating this over here in June and July, but then they go in number 9, Section 9, by letter dated August 1st, which you see now they're starting in August 1st when they should have put that 317 way over here in August 1st. Matter of fact, it should have been way down here. Matter of fact, by the looks of it, by the dates here, it should have been another page or two down. August 5th, 2008, claimant requested a hearing on the TD issue as well as certain factual allegations regarding his release to work by Dr. Gross. Therein, claimant also noted that his medical care had been taken over by Dr. Hansen. They knew it was. On August 15, 2008, defendants served upon claimant objection to request for calendar as well as notice of service integratory to claimant and request for production of documents and things. Hereinafter, defendant discovery request. A true and correct copy of defendant discovery request is attached to here too as Exhibit D. By letter dated August 15, 2008, here we go. By letter dated August 15, 2008, defendants request claimant to sign 5 copies of HIPAA complaint authorization direction for release of medical records, as well as an facility-specific medical release for West Valley Medical Center, St. Alfonso Regional Medical Center, St. Luke's Medical Center, Regional Medical Center, and Primary Health. A true and correct copy of defendant's August 15, 2008 letter with the enclosed medical releases are attached here to Exhibit E. So, are you saying right here, y'all didn't even send me anything to sign until August 15th? But you had these records before August 15th. During a telephone conference between affiant, and claimant on September 8, 2008, claimant indicated that he was not willing to sign any medical releases. In addition, he indicated that he intended to serve discovery request upon defendants. During a telephone conference between affiant and claimant on September 9th of 2008, claimant again indicated that he was not willing to sign the medical releases, but that he had mailed his discovery response. On September 10, 2008, defendants received claimant's letters and discovery, a total of 62 pages of medical materials included letters and documents dated August 22, 2008 through September 5, 2008. Hereinafter, collectively and individually referred to as claimant's letter submissions. Now, why would you do that? Why don't you individually state the letters? Because I'll tell you why. For one thing, when the State Insurance Fund mentions on September 10, 2008, defendants received letters and discovery, a total of 62 pages of material documents dated August 22, 2008 through September 5th. Now, what it was is I was in the process of doing a bunch of filing and stuff, and some of these were already dated on August 22nd, but you see what really happened is I snapped on August 22nd, and I wasn't able to complete those and get those mailed in because that's the day that I ended up going to jail. I ended up having to have all my medical providers testify, my doctors testify at my hearing. I took it to a jury trial. I was found not guilty for eluding a police officer because I snapped. It was in relation to this injury and the stress that these people had put me through. And then, of course, the August 21st letter that y'all got from one of my doctors saying that he fears that I might snap, and in reality, I guess I did. So through September 5th, because I didn't get back out of jail until, I went in August 22nd, but I didn't get out until like September 2nd or something like that, or 3rd. So in here, so number 16, section 16. By letter submission dated August 22nd, again, they weren't actually submissions. They weren't actually mailed, and they didn't deliver them or receive them on August 22nd. That was the date of them. They didn't get them until the following month. Claimant indicated that he was unwilling to answer the interrogatory to claimant due to phrases such as during my lifetime. In response to defendant's interrogatory number 10, which requested claimant stated the name and address of employers during his lifetime prior to the date of the claimed accident. Claimant disclosed employment, picking up dog waste. At age 5, a true and correct copy of claimant's letter of August 22, 2008 is attached here to Exhibit G. Now, what it was is, I was wanting to know. They wanted to, over my lifetime. They wanted to know all the jobs that I did, that I made money over in my lifetime. Well, when I was 5 years old, I went out and picked up dog crap and made some money and ran to the candy store, I mean, it was a job. Is that what you mean by a lifetime? I mean, that was self-employed, under self-employed. I'm not trying to be an idiot or, but, this is what, by separate letter submission dated August 22nd, 2008, claimant stated that he was unwilling to respond to the request for production of documents and things, as he requested the meaning of the phrases and things, questioning whether defendants would like use soap or holy socks. A true and correct copy of claimant's letter of August 22, 2008 is attached to. By separate letter submission dated August 22, 2008, claimant stated that he had provided the State Insurance Fund with a medical release and therefore would not sign the general or specific release provided by our office. A true and correct copy of claimant's letter of August 22, 2008 with the attachment is attached here too as Exhibit 1. By separate letter submission dated August 22, 2008, claimant stated that he would continue to refuse to sign anything, presumably the aforementioned discovery request and medical releases, a true and correct copy. To date, claimant has refused and or failed to provide defendants his response of defendant's discovery request with the exception of the unreasonable and responsive assertion contained in his letter submission to the Industrial Commission, which was, if they tried to do this to me, how many innocent people have they done this to and actually got away with it? Without full disclosure by claimant, through discovery response and execution of medical administrative record releases, defendants are unable to identify prior medical providers and cannot obtain pre- or post-injury medical records without a HIPAA complaint and or facility-specific releases. Without this basic information, defendants are unable to fully investigate and defend their interests or present a viable case. Further, your affidavit side not. Now, but you already had these. So, are you saying that all this time also you were lying to the Industrial Commission? And you were wanting, and then after over time, I find out that, you know, how it all really works is you all were wanting me to cover up their fraud, is what it comes down to. And then you want to sanction me because, and then for me to file a letter requesting to go to the Supreme Court in June of 2009, and then you denied it, and you refused to allow me to bring any of these documents in regards, or to have them in regards to the fraud that they had committed. You wouldn't allow me to present these on the record, to have a hearing on it. Instead, y'all fancy foot meat around to where then I didn't have the hearing because, I don't know, whatever you guys pulled. But there it is, opening argument. There it is. It's an affidavit of counsel in support of motion to compel. But here you guys are saying that without a HIPAA authorization, but y'all already received them. You didn't even protect the names, numbers, or anything. You didn't even put in a safeguard to protect any records of family members or anyone, because you all didn't think I was going to make it this far. This is my open argument. 30 minutes? I guess that's what I have, right? There it is, man. But I hope, I don't know what they're going to do, but here I am. It's I just want to bring it to an end, but they want to continue on. I'm going. Oral argument, it's going to get ugly, I know that.